the defect is pointed out that applet number 3 of CC of DP has not been made party. What happened in this case? Before filing of this appeal, applet number 3 has died. That's why I have filed IA for impleading legal. जिसमें हम आई किया था सेकंड एप्लीकेशन से मैंने
अब जब केस फॉलो
नहीं कॉमन ऑर्डर से हुआ था।
कॉमन ऑर्डर नहीं होता है सर, यहाँ पर एक एक केस फॉलो आउट होकर ऑर्डर होता है, लेकिन हर एक का अलग अलग ऑर्डर ड्रॉ नहीं करते हैं, क्योंकि क्या बोलते हैं नॉन सीरियस लिटिगेशन के लिए हम लोग हमारे स्टेनोग्राफर के पास टाइम नहीं है। एक एक केस फॉलो आउट होता है यहाँ पर, हर एक की इनफैक्ट ऑर्डर होता है। तो अगर आपने आईए फाइल कर दिया तो प्रिंटली में आपका डिस्कस नहीं होगा।
नहीं तो हम इसमें दे रहे हैं इसको मेंशन कर दे रहे हैं 16 को इसको 16 या 17 को।
आपका कब का इंट्री ऑर्डर कब एक्सपायर होता है?
9 जनवरी का है, तो प्रॉब्लम 25 तारीख को हुआ है।
आपने आईए फाइल कर दिया है ना, आपका केस डिसमिस नहीं होगा, क्योंकि आपके इंट्री ऑर्डर में क्या लिखा है, और टू फाइल इंटरडिक्टेड की एप्लीकेशन इन कनेक्शन विद वन और द अदर डिफेक्ट लिखा है कि नहीं? पढ़िए। ठीक है, कोई बात नहीं, लिखा है ना, कोई बात नहीं, इसीलिए लिखते हैं क्योंकि हो सकता है किसी डिफेक्ट के लिए आपको आईए फाइल करना पड़े।
हम दे रहे हैं
वो एक ऑल्टरनेटिव ऑप्शन हम दे ही देते हैं, क्योंकि there could be, you know, second appeal, there could be many reasons for which is beyond your control, you can't do it। तो आइए फाइल कर देने से आपका ड्यूटी नहीं, ठीक है?
With your lordship permission,
जब रेगुलर में जाएगा उस
with your lordship permission, from the list, lordship, may I mention one case? Daily serial number 11, serial number 11. I pray in this case next week, lordship, because yesterday I have received a counter affidavit.
सर ऐसे
second appeal में
आपको लग रहा है कि हम इतना कुछ पहुंचेंगे?
कुछ
घर जाना आपको, हम नहीं पहुंचेंगे उतना दूर। There is no likelihood of being taken up. I'm telling you, अभी तो ये वाला चलेगा, ये वाला चलेगा अच्छा खासा।
all like you.
It may not be possible, छुट्टी के एक हफ्ता पहले हम लोग नहीं कर देंगे।
After vacation रखते हैं।
ऑटोमेटिकली चला जाएगा, लेकिन जब केस कॉल आउट हो तो आ जाएगा। इन केस अगर कॉल आउट।
If I not come, lordship, my junior.
हाँ, yes. Anybody?
From supplementary list for Lok Adalat, item 6, second appeal 46. Item 6, second appeal 14 of 2017.
On behalf of the parties, this matter will not be resolved in the absence.
Item 7, second appeal 262 of 2017.
I'm appearing for the contesting respondent. I have talked to my client. They are not in a position to come, and so there is no likelihood.
Essay number 262 of 2017. Counsel for the respondents on instruction submits that the respondents are not doing communication. Accordingly, this case cannot be related. ये सब में इनको डेट दीजिएगा, सब में लिस्ट
पार्टीशन सूत्र तो हो नहीं सकता है, एक कोर्ट में हम जीते हैं,
उनको नहीं माने,
हम तो चाहे तो
नहीं,
डिस्क्लोजर
वो आ नहीं पाएंगे, ये हमको बोले कि
नहीं
कि आज
वहीं का
रात
डालसा में भी तो हो सकता है, वहाँ पर जिस डिस्ट्रिक्ट में वहाँ भी तो हो सकता है।
वो बंदा आना ही नहीं चाहता।
नहीं, कल हम उनको रात में बोले कि कल एक दिन में हम नहीं आ सकेंगे, बाहर है, यही हमको बोला।
वैसे पॉसिबिलिटी है?
उस विषय में यही बोला, हम आ ही नहीं सकते, तो आप सब क्या डिस्कस करें।
सब में डेट पड़ेगा।
हाँ, डेट।
और जब डेट पड़ेगा, जब हियरिंग होगा, तब आपको मीडिएशन का मन होगा।
जी
सिंपल।
जी,
डिस्पोज हो जाएगा केस में।
Item 8, second appeal 308 of 2018.
सब में ना लिस्टिंग का डेट भी कोई
In this case, my lord, the mediation is successful as per the report.
सक्सेसफुल।
And my lord, may kindly see the report has indicated that flag M. It is have entered into compromise. The compromise is also there.
You have to file your joint complaints. The file.
No, it was before the mediation for this. That's
The mediation is successful.
yes. And thereafter, my lord, as I could see from the report, your lordship, both the parties, para two, my lord, may kindly see, both the parties will come into possession of respective shares by January after getting the same measure through the appeal. That's what is written. So these all will have to be done before the consent. These things will have to be done by the Jalsa.
आप जाइए मीडिया, आप इससे मिले. You can do one thing. This can be, if you, where is the other side?
Other side, in this case, my lord, the notices were not issued. My lord has
वहाँ कैसे लोग आते हैं?
ये हजूर का ऑर्डर से किया था 9/7/2025 का ऑर्डर देखा जाए. This matter was listed for admission.
Yes, I understand that.
Thereafter,
Now,
my lord,
when further, since the parties have settled their dispute, so we have to issue notice to them joint
Yes.
compromise petition they are filed, correct?
yes, and apart from that, my lord, both the decree has to be set aside.
Yes.
And in the terms of the compromise,
It has to be
decree has to
disposed
be
of.
filed.
Yes.
As per the
जब तक नहीं
1970.
होगा तो कैसे होगा?
कैसे हो?
तो नोटिस तो करना
नोटिस
पड़ेगा.
करना.
जब कॉम्प्रोमाइज हो गया हमको बुलाएंगे. How many people are there?
पार्टी का डेथ हो गया, उसका हमने एक सब्स्टिट्यूशन पिटीशन में फाइल किया.
That is pending.
11/7/32 of 20.
Notice हुआ है.
Notice is
आइए में भी notice.
IM में भी notice. As I remember.
The legal years of that person had participated.
Yes.
So defective नहीं है ना.
बहुत से लोग, 23 लोग.
कोई बात. Who has died? Respond number 1.
हाँ. उसका IM पिटीशन हमने 11,732 फाइल किया.
When Council for Dapina discussed, he submits that matter was sent for mediation and the mediation has been successful. As per the mediation report. He has further submitted that the parties had participated at the stage of mediation, but so far as this case is concerned, they have not entered the case. He has also submitted that IE number 11732 of 24 has been filed for substitution of respondent number 1, namely Roman Mehto, who died on 14/8/2024.
It is within time.
Sorry.
It is within time.
The
Substitution petition is within time.
substitution petition has been filed within time. The learned counsel has also submitted that legal years of Roman Mehto had participated in the mediation process. That's it.
But I will have to verify.
अच्छा, कोई
But I
बात नहीं,
think
ये last sentence
they-
है. He has submitted that if the parties appear then if the substitution is allowed and the parties appear, then under such circumstances, the case itself can be disposed of by way of joint compromise in terms of the mediation. Correct?
Yes.
This case has not yet been admitted.
They
However,
have
considering
agreed.
the reported submissions,
They have agreed that
अभी ऐसे नहीं होगा. This case has not been admitted. However, in view of the reported submissions, let notice be issued to the proposed legal heirs and successors of respondent number 1, namely Roman numeral, in IA number 1172 of 2024, for which recusals be filed by 22nd December.
for others
The
also,
let notice be also issued to the respondents except respondent number 1
put together 23.
so that the matter be disposed of if any joint compromise petition is filed.
They have already filed. That is in the record.
Who has filed?
On the basis of that, the mediation has been successful.
तो उससे नहीं होगा ना जॉइंट कॉम्प्रोमाइज के बिना तो फिर आपका विड्रॉ कर दीजिए आपका सेटल हो गया
नहीं।
विड्रॉ इट
Okay.
दिस यू कैन डू प्रोसीजर है भाई
नहीं, नहीं.
डिग्री सेट असाइड होगा जॉइंट कॉम्प्रोमाइज होगा
1970 सुप्रीम कोर्ट करते हैं.
इसके लिए क्या होता है द रिक्विजिट्स फॉर नोटिस we send through ordinary process and speed post दोनों पर 22 तक आप फाइल कर दीजिए सबका उसका नेक्स्ट स्टेज में हम लोग करने देंगे जब कॉम्प्रोमाइज हो गया अब उनको लेके आइए फिर क्या सोचना है
नहीं, compromise तो इन्होंने किया है before the Dalsa Act civil court itself. उसमें वहाँ पर तो क्या हुआ नहीं हुआ that
हाँ,
I'm not
that's
clear. So, but they have informed me also.
इसको 20 तारीख को रखें क्या 20 जनवरी
ठीक.
आप नोटिस कर देंगे क्योंकि 26 को अमीन का मेजरमेंट का है उसमें
जी. हम इसको करवा दें. जनवरी में इन्होंने ऐसा लिखा है कि आफ्टर मेजरमेंट हम अमीन बाहर
हाँ
हुआ.
इसीलिए 20 जनवरी
I think 9 second quick.
20 जनवरी
There was
को
3-4 of
supplementary
2018.
सप्लीमेंट्री इस बीच अगर हो सके तो जॉइंट कॉम्प्रोमाइज फाइल कर दीजिए इफ दे आर रेडी दे शुड नॉट बी एनी प्रॉब्लम
Let them proceed.
इसमें सेटलमेंट हो गया लास्ट टाइम लिटिगेशन जो है we watched that referred the matter for litigation which has been
सेटल
हाँ said it is settled your lordship but 3 respondents had died lordship we filed I for substitution
सुपर इशू इन सब
your lordship once we had filed an I but that had to be withdrawn because it had to be amended your lordship new I it has notice has not been issued your lordship notice में issue करके date दे दिया जाए they will file the वकालत नामा your lordship
which is that
I number is I number 16328 your lordship is for substitution and 16611 is for limitation.
इसको
Combination of delay in filing the substitution.
who has expired
Your lordship, respondent number 1 filed in February.
I fail to understand why you have to mix up all the respondents आपको स्टेशनरी का कमी है कि आपको लिटिगेंट का मतलब ऐसे खिचड़ी बना के क्यों बनाते हैं सबका डेट ऑफ अमिटमेंट सब चीज अलग अलग है ना I number 16328 of 2025. Counsel for the appellant has submitted that the matter was referred to mediation and the mediation has been successful. However, the fact reveals that respondent number 1, namely the actor Ravani, respondent number 5, namely Parvati Devi, and respondent number 12, namely Sakina Devi have expired on 22/5/2023, 7/9/2017 and 25/2019, for which IA number 16328 of 25 has been filed with a prayer for substitution and for setting aside abatement. Another petition being item number 16611 of 25 has been filed seeking confirmation of delay in filing the petition for substitution. This is an admitted second appeal.
No, Your Lordship, partitions.
Yes. The council has also submitted that if the notice is issued to the respondents and also to the proposed legal years and successors of respondent number 1, 5 and 12, then a joint compromise petition may be filed in this case. The second appeal has not yet been admitted. However, considering the submissions, let notice be issued.
Your Lordship, instead of notice, some time may be given if file Bagada from Your Lordship. I'm just praying this because the applicant is a very poor lady, Your Lordship.
For that, let notice be issued in ID number 16328 of 2025 and also in IA number 16611 of 2025 through ordinary process. Through the concerned police station, कितने लोग हैं?
Your Lordship. 10.
कितना पुलिस का? Through ordinary process. Let notice be also issued to the respondents in the second appeal. In IA number, there is one petition for condonation of delay.
16328.
IA number
16328 is for condemnation.
16328.
Is for condemnation.
Sorry.
Your Lordship, 16328 is for substitution, 16611 is for delay. Condemnation of delay.
आपका appeal में तो barred है limitation से. That has been condoned. नहीं, वो नहीं. Let notice be issued in the main appeal upon the respondents except respondent number 1, 5 and 12 through ordinary process. The requisites for the aforesaid notices be filed by 22nd. Proposed legal years को जाएगा और other respondents को. Post on 28.
Final disclosure from supplementary list item 1, first appeal 124 of 1023.
May please.
the order sheet, so that's not cut here side. It's a set. Yes, please. Record.
DT, my submissions today are broadly on three parts. You may need not note it, just highlighting three parts. One is primarily factual, and the other two are primarily legal. The last is with regard to the impact of section 34 of the specific relief act. The other legal argument is with regard to interpretation of section 54 of the Trust and Property Act, in which I'll cite a judgment which may at first blush look to be against me, but it clarifies the legal position, and therefore as an officer of the court I felt duty bound to place that judgment. And factual argument is something which is developed on adopting the classic process of preparation, that is preparation of list of dates. My exercise has led me to understand the following. My respectful submission is that a ridiculous story, the leadership, it was 2:30 AM, I could not make it enough for your ladyship's consumption. But then I may place my submissions based on this.
You give me the dates.
Yes, that's what I'm saying. And what I wish to say is this, your ladyship, that a ridiculous story is attempted on part of the plaintiff, meant to be believed by all of us. The plaint on plain reading did not clarify it, but when we note the dates and events, it's clear that what they are saying is that on 7th of February 2014, there was the first sale date.
7
February 2014 is the first sale date. That's exhibit 1. Both parties rely on that sale date, registered sale date. That's the date on which the deed was executed. That is the date, interestingly, on which the deed was executed, the deed was registered, and the checks were issued. 4 checks. What is important is, and your ladyship cannot write it right away, is the date of the next sale date. Because something is coming in between the two. The date of the next sale date is 17th of May. Followed by the same drill. That means execution on 17th of May, registration on 17th of May, and passing of 4 checks dated 17th of May. The description of property covered by the 2 deeds would show that they belong to the same khata, plot, everything, only acre is different. The first one is, and that your ladyship will find at Schedule 2 and Schedule 3. A comparison of Schedule 2 and Schedule 3 would suggest that the deeds are with regard to 2 acre 6 decimal and 1 acre 32 decimal. Khata number, plot number, thana number, everything identical. In fact, I was slightly confused when I was reading the boundary, because the boundary suggests that it's the same plot, as if.
First one is 2 acres 6 decimal.
6 decimal. Second is 1 acre 32 decimal. It must be adjacent properties. What's relevant is that something happens between the 2 deeds according to his story. His story is that the checks were given. But on 22nd of February 2014, I wrote a letter to him, which is Exhibit 2. This letter purports to say, I am saying, I'll just read the language. Because your ladyship will have to appreciate whether after writing this set of letters, is it possible that there will be another deed in May. I am writing a letter. आदरणीय सत्यानंद मोहन राजू जी नमस्कार. आपको सूचित करना है कि जैसे हम लोगों की बातचीत हुई, आपने अपना जमीन जो मौजा 100 की जमीन को दलील के माध्यम से मुझे रजिस्ट्री की गई, हम लोगों का तय था कि म्यूटेशन होने के बाद ही तयशुदा रकम आपको देना है, इसका चेक भी दलील में अंकित कर दिया गया, लेकिन जब हम अंचल अधिकारी पर म्यूटेशन दलील को पेश किया तो पता चला कि संबंधित खाता प्लॉट सरकारी जमीन घोषित है, म्यूटेशन नहीं हो सकता है। हमको उसकी जानकारी थी, हमने अपने स्तर से काफी प्रयास करे ना। लास्ट सेंटेंस इज इम्पोर्टेंट। अतः आपसे निवेदन है कि मेरे द्वारा दिए गए चेक हमें लौटाने की कृपा करें तथा नियम संगत दलील को रद्द ब्रैकेट कैंसिल करने की प्रक्रिया करें। दिस इज अ स्टोरी developed by them that this is already my mindset, that I am saying that your land is not worth being transferred to me, not worth being taken. Give the money, the check back and get the deed cancelled. And this letter is not the only letter, then that letter is followed by a reminder. The date is,
This is exhibit number.
this is exhibit 2. Then comes reminder, 28th of March 2014. This is exhibit 2/1. आदरणीय सत्यानंद मोहन राजू जी नमस्कार। मैंने दिनांक 22/2/2014 को पत्र के माध्यम से आपको सूचित किया था। That means it's a reminder to the first one कि आपके द्वारा लिखे गए दलील को आप रद्द करते हुए मेरे द्वारा दिए गए चेकों को वापस कर दें, क्योंकि आपकी जमीन पर मेरा कोई काम नहीं हो सकता है, लेकिन बाध्य होकर मुझे आपको पुनः पत्र लिखना पड़ रहा है। आपसे तो फोन पर भी बात नहीं हो पाती है। प्लीज नोट द लैंग्वेज, इट्स अ कॉन्वर्सेशन बिटवीन टू इंडिविजुअल्स। कृपया यथाशीघ्र मेरे चेकों को लौटाने की कृपा की जाए, अन्यथा बाध्य होकर मुझे न्याय की शरण में जाना पड़ेगा। Having said that, now their story is that I wrote another. Then comes the exhibit 2/2, by which he writes a letter to me, bearing purported signature of mine in the endorsement of receipt. शर्मा जी, चेक वापस करने के संबंध में आपके द्वारा दिए गए सारे चेकों को मैं वापस कर रहा हूं, जिसका विवरण निम्न है। So his story is that I demanded checks and he has given it back to me. And what is the
date
what
of
is
exhibit 2/2?
8th of April 2014. Now please test if this set of events actually happened. Your Ladyship, I don't deny that checks have not been encashed by them. I have denied that checks have never been returned to me. Now please appreciate, in this set of factual scenario, can there be another set of deed, another deed of 17th of May 2014 for a property belonging to same plot, same khata, which according to both of us, or at least according to me, is not fit to be transferred. Mutation नहीं हो सकता है, चेक वापस कर दीजिए, और कर भी दिया। And then he says 17th of May 2014 another deed, and then again 3 more letters.
You have made out a story that the checks were not encashed, right?
And checks were not returned.
No, we'll see that later.
Yes.
Checks were not encashed,
Not encashed.
but at their insistence, you have paid the entire
I'll
consideration.
come to that later, Your Ladyship. I may or may not be able to prove it. That's a different thing.
The conduct
I'm getting
that
it.
he, after giving the check, and without getting it back, without ensuring that it is not encashed in any manner and it is not misused, you will pay the entire consideration money back to him.
Yes, the relationship was not of bad faith those days. It's come like this now.
Back
I did not know any dishonesty on his part.
No, even if the
One
relationship is not.
can. Therefore, we are having so many cases. People act foolishly to our advantages.
So when it
Therefore,
comes
we have
to
so
you,
many
you
cases.
become foolish.
One may be foolish. One may be foolish. That can't be ruled out.
Yes, that is this.
Please, let me just complete this narration, Your Ladyship. Please, I beg of Your Ladyship to just let me complete this. Then he says, and these letters are interesting. Then he says that then both of us say that 17th of May 2014 the deed happened. Now after 17th of May 2014 deed, then again there is a letter. 17th May 2014 deed is exhibit 1/1. Then we again come back to 2 series. 1/6/2014, identical letter. identical to,
This is exhibit.
this is exhibit 2/3, identical in language to 22nd of February. Same drill being repeated. So unbelievable, your lordship. So unnatural conduct on part of any individual. 1/6/2014, then another letter. सत्यानंद बोल राजू जी नमस्कार, आपको सूचित करना है जैसे हम लोग की बातचीत हुई, आपने अपना जमीन जो सो है रजिस्ट्री की, हम लोग तय हुआ कि म्यूटेशन होने के बाद तयशुदा रकम आपको देना है, इस चेक भी दलील में अंकित कर दिया गया वर्ड टू वर्ड से। लेकिन जब हमने अंचल और म्यूटेशन का दलील पेश किया तो पता चला कि जमीन वो सरकारी जमीन है, म्यूटेशन नहीं, उसके पूर्व में भी पूर्ण जमानत दी। हमने अपने स्तर से काफी प्रयास कर लिया, आपसे निवेदन है कि मेरे द्वारा ये चेक में लौटाने की कृपा करें, नियम संगत दलील मदद करने की प्रक्रिया है। आइडेंटिकल लैंग्वेज। Then next letter, then identical reminder, exhibit 2/4. May I point out the date? 15/6/2014. Exhibit 2/4. It is same as the language of 28/3/2014. एकदम एब्सोल्युटली सेम। आपसे तो फोन पर भी बात नहीं हो पाती है, फोन पर बात 4 महीने पहले भी नहीं हो रही थी, फोन पर बात 4 महीने बाद भी नहीं हो रही है। कृपया यथाशीघ्र चेक को लौटाने की कृपा किया जाए, अन्यथा बाध्य को न्याय की शरण में जाएंगे। एक साथ इसको तैयार किया गया। दैट्स माय कंडीशन। ये तो हो गया 15 द
15/6 हुआ ना डिवाइड।
yes 15/6.
So next.
Then the same similar letter 1/7/2014. Exhibit 2/5. Letter of return of 4 checks. मैं सारे चेक आपको वापस कर रहा हूँ क्योंकि विवरण नहीं मिल रहा है। Your ladyship, please appreciate and accept that these documents have been created subsequent to the second deed. His pleading in plaint is that after 1/7/2014, he has not given date, but pleading in plaint at paragraph 14 and 15, your ladyship will find this. After receipt of checks, that means all the 4 checks, all the 8 checks. After receipt of checks, 2 sale deeds were obtained by defendant from, both the sale deeds were obtained by defendant from the sub-registrar. If we go by chronology, then it comes like this. That I have taken the sale deeds after July. Because he says, after receipt of checks, 2 sale deeds were obtained by defendant from in clandestine manner on the basis of registration slip. Handed over by petitioner in good faith. Plaintiff in good faith. That's what his case is. According to the chronology set out here. So chronology made out from the pleadings. And he says possession was delivered. Then, in paragraph 22, something interesting comes. He says that 12/8/2016, he entered into an agreement with one Arun Thakur. That date he doesn't mention intentionally.
12/8/2016.
12/8/2016 is the date which can be made out from the exhibit 3. He starts with narration about the subsequent event first. 23/8/2016 was the legal notice according to him. 23/8/2016. Legal notice. Then 9/9/2016 is reply to legal notice. These facts have been asserted in plaint para 18 and 19. Reply is 9/9/16. Legal notice according to him is for return of sale deeds and repudiation so called of the agreements. He said agreement at one place, he said deed of at one place, repudiation. And 9/9/16 is my refusal. And then he says in paragraph 22, the word used is thereafter. Thereafter, there was an agreement for sale with Arun Thakur. And that agreement of sale with Arun Thakur is actually dated 12th of August. before this, not thereafter. So this is factually incorrect. Interestingly, while he has portrayed that there were 4 letters, the leadership has noted, there were 4 letters of demand from given by me to him, 2 letters and 2 reminders, which are dated 22nd of February, 28th of March, 1st of June and 15th of June. In the first sale deed, in the first plaint which he had filed, which is Exhibit E, he says there were 2 letters. When he filed the suit subsequently, he was able to fabricate 2 more. These first 2 letters, your ladyship, have definitely been fabricated. So the first sale deed which he had filed, your ladyship sees first suit, the first plaint of the suit, first suit. The difference is only between para 9-10 of the old one and the new one. The old one and the new one, paragraph 9 and 10 are slightly different from each other with the purpose itself. Para 10 says, the new old para 10, that on persistent demands of the plaintiff to make payment of the price of the Schedule 1 and 2 lands, the defendants wrote 2 letters requesting the plaintiff to cancel the sale deed and to return the checks which were issued by him to the plaintiff. Para 10 of the new plaint says a longish paragraph. It says, thereafter on 22/2/2014, defendant gave a letter to plaintiff stating that in plot number so. So in paragraph 10 now he narrates about 2 letters given with respect to the first sale deed. And then he talks about the next sale deed. Then it is interesting to note how he narrates about the letters, set of these 3 letters, 2 from me and then 1 from him, 2 from me demanding return of checks and 1 from him giving return of the check, covering return. How he narrates about that. That's paragraph 13. Plaintiff also returned on 1/7/2014 all the 4 checks for a total amount of so and so to the defendant, which defendant said given to plaintiffs on the day of executing the second sale deed. The defendant has put his signature and token of proof of receipt of 4 number of checks mentioned above. Not a word about these letters, but these letters are indexed. So I am trying to decipher why this difference between the 2 plates. And then the list of date makes it clear that it is actually a ridiculous story which he has been advised to develop to suggest that after the first deed there were 2 letters demanding from him the checks. Because he has to justify his case that check was never encashed and it has been returned back. Now this is factual aspect. Based on this factual aspect, yes, I was waiting for this. Yeah,
even if these documents are not there, they are not there.
I am saying that.
Let it be.
Yes, then we'll come to the legal part. These, no, but these documents are relevant to consider that he has set up a false story. When it will come to judging the truthfulness of the two rival version on facts, for example, possession, you will have to see the conduct of the parties. Therefore, at an outset, I pointed this out. I should have first argued the legal aspect because that's the moot aspect. The moot aspect is point number 1.
We will gaze through the law which is involved. See, one party is saying one thing, you are saying another. And whatever you are saying is not reflected from your written statement.
I am demonstrating from the plate.
No, that's right. But you see, some kind of
I have given a suggestion.
There is an improvement in the. There was a difference in the stand. That those particulars.
Those are submissions. Those are submissions.
Not submissions. Those particular paragraphs should have been brought to his notice during the cross-examination.
I have exhibited his plate.
That's right.
I have exhibited his plate and I have given him suggestion. That is, the letters are forged, subsequent ones. Anyways, I concede one thing.
Your Lordship, these statement, these letters were specifically mentioned in my claim, and no denial, absolutely no denial.
Ultimately, both parties admit that the payment was not made.
No,
Therefore, I have to satisfy your
we have
ladyship
made a
section
very
54.
important statement right now that there is no denial of these letters. Is there any denial of these letters in the written statement?
Please see what I have stated in the written statement.
Okay, let's see.
Para 10 and 12 we have stated.
And there is no law which says that a non-denied statement is bound to be taken as admitted.
It is.
No, it is not.
Your Lordship, I
Please
was
say
just
that.
referring to that. It is order 6.
We will argue
order
like
is
this.
rule 5.
Are you arguing like this?
No,
No,
please,
you have
because-
that's a misreading of that order, I would say.
Just a moment.
It says that the court has a discretion to ask you to prove it. And I am highlighting a reason why court should ask you to prove it.
Where is your denial about these documents? These documents were then
No,
annexed along.
documents have not been denied.
They have not been
They have not
denied.
been denied.
These
Only
documents
only my stand is paragraph 10. Just
But my apologies for intervening.
it's all. Actually, half reading of the provision of law is not going to do that. No problem. So paragraph 10, your ladyship, is my case. My case is in somewhat addition of part of what they have said. They submitted, although it was agreed between the parties. So I am admitting that the checks issued by the defendant mentioned in the CAPs will be encashed by the plaintiff only after mutation in respect to the lands mentioned in the proceedings. And in pursuance of the same, the plaintiff retained. So your ladyship, part of what is sought to be projected by that letter, that I was of the view that only after mutation it can be encashed, is true. But then the fact that check was handed back to me stands controverted, stands denied by a contrary statement made by me that the plaintiff retained those checks with them.
But the fact remains that these checks were never encashed.
Yes, absolutely. That brings me to the legal argument.
And the fact
Absolutely.
also remains that you also paid the entire consideration amount as per your case.
More than that, as per my unproved case, I may not be
Yes.
able to prove it now also.
That's right. Right? You have paid the entire consideration amount.
Or I might not have paid. Ultimately, court will decide. I have to advance my argument taking into account the factual situation. If I have paid, then what? If I have not paid, then what?
And
I admit.
And you see, the letters as such are not denied.
Letter as such has not been.
The letters as such.
In the pleadings, it has not been denied.
Yes.
Pleading is defective in that sense.
Yes.
But therefore, the lawmakers have taken care for such a situation where, in order 8 Rule 5, every allegation of fact in the plaintiff not denied specifically or by necessary implication or stated to be not admitted in the pleadings of the defendant shall be taken to be admitted except as against a person under disability, provided that the court may in its discretion require any fact to be admitted, not any fact so admitted to be proved otherwise than by such admission. Therefore, it's not an absolute case that every fact which I have not denied will be deemed to be admitted. Doctrine of non-traverse has some limitations. And I am showing from the material, from the plate, story developed in the plate, that how it is ridiculous and not fit to be accepted. But, and Your Ladyship, I must add something. There is a suggestion also given in the cross-examination to the other side that there is forgery. I mean, this letter is not genuine. Anyways, my respectful submission is that I have to satisfy Your Ladyship on the legal aspect. These letters or no letters, check returned or not returned, the fact that the amount covered by the check was not paid by way of honoring of that check is an admitted fact. Based on that, where do I stand? How section 54 should be interpreted? The answer has been given by the Honorable Supreme Court in a case non-suiting a party like me, in the sense that the party who argued that despite non-payment, by virtue of language of section 54, transfer should be taken to have happened, was rejected by the Supreme Court in that case. And they clarified as to in what case, in the event of non-payment, a sale should be treated to have actually happened. Therefore, that judgment is important. Section 54's language may kindly be seen for a moment. The Ladyship has seen it 100 times, but for my satisfaction.
So you are waiting for a case. This case will take quite some time. It's a first appeal. This case will take quite some time.
Next case is
So 1 घंटा तो लगेगा. So you are for 1 hour you are free.
she was always very kind in that sense.
I wait continue. But these cases are bound to take time. 3 घंटा का ऑपरेशन 2 घंटा में नहीं कर सकते. 3 घंटा देना होगा. चलिए.
I don't know about the surgeon, but at least the compounder assisting is not that.
Let's.
The language is same is a transfer of ownership in exchange for a price paid or promise of part paid and part promise. This language leaves scope of lot of arguments. Now it has been clarified that what matters is the intention of the parties. Conveyance would happen if the parties in, and it would not happen when. They said, if passing of money was a condition precedent intended by the parties, then transfer will not happen till the money is passed. That's the fine distinction, but that's the very clear distinction. If passing of money is not condition precedent, then the remedy of an unpaid seller is to sue for price, sue for that money. So whole test is whether it is condition precedent or not. Let me straight away give that judgment. Condition precedent is the true test. This pair of words, Your Ladyship, will find at paragraph 17, 18 and 19, at 17, 18 and 21. But I would request Your Ladyship to consider the judgment in little elaboration. Please come to paragraph 1. Appeal is directed against the judgment rendered by a single judge of High Court at Madras in second appeal, by which decree passed by the subordinate court declaring the appellant to be owner and directing the respondents to hand over possession of the same to the appellant in gain profit with proportionate so percent. Facts emerging from the record. Para 2 is relevant. Suit properties originally belong to the family of the respondents. first respondent and the second respondent sold the properties to the appellant for a consideration of rupees 43,000 by a deed. Out of sale consideration of 43,000, 3,000 was to be appropriated towards the discharge of mortgage, which is the relevant fact in issue. The balance, the last line is important. The balance of rupees 40,000 was to be paid before the sub-registrar at the time of registration of the sale. So I'll just pause here for a moment, rely on my submissions. It is this particular stipulation in the sale deed which was subject matter of interpretation. In the interpretation of this stipulation, the Honorable Supreme Court eventually holds, agrees with the High Court and differs with the trial court to hold that if 40,000 fully has not been paid before the sub-registrar, there will be no sale. In this case, what had happened? One side was saying that I have not been paid at all. Other side was saying that I have paid, but I have paid part, and remaining part is to be paid by me. So he also admitted that full payment has not been made at the time of registration of the sale. It is the case of the appellant that before the document could be presented for registration, he paid to the respondent a sum of rupees 25,000. Appellant is the buyer. In this case, the appellant is the buyer. So buyer is saying that I have paid 25,000. Now para 4. On presentation of the document for registration, the sub-registrar issued summons to the respondents, pursuant to which the first respondent appeared before him. The first respondent admitted execution of the deed but refused to put his thumb impression or to sign the endorsement to be made on the deed in token of admitting execution on the ground that respondents were not paid the remaining consideration. Here what happened, Your Ladyship, the registrar forced the sale. Trial could agree with the registrar. Registrar forced the sale, saying that no, yes, whatever he has paid, remaining portion, he will pay later, and only after payment you give him possession. But you can't say that the sale will not take place. So sale took place. Para 5. According to the appellant, ever since the date of execution of the sale deed and the date of his registration, he was ready to tender the balance consideration of 15,000. Please mark. The buyer, and that's what the courts have relied upon. The buyer was also saying that I will pay 15,000 only. He never said that I will pay entire 40,000. What to talk of actually having paid 40,000. Therefore, but the respondents were unreasonably refusing to receive the same. Para 6 may be ignored. Para 7. On service of summons, the respondents appeared and contested the suit filed with the appellant. They denied having received 25,000 as advance. In short, the stand taken by respondent, that means the seller, was that as the appellant has not paid the balance consideration of 40,000 as mentioned in the deed, the title never passed, and therefore the suit of declaration of title to the suit properties was not made. So, slightly converse situation, Your Ladyship. Here the seller has come to the court saying that no title is passed on. There the buyer was coming to the court saying that title is passed on. The reason why their buyer came was that buyer was not given possession. Here I am in possession, therefore he has come. Or to be fair to him, he doesn't admit possession, so I am in possession of the deed, so he has come for tender of the deed. Para 8. Necessary issues for determination of framed by the trial court, the parties laid evidence on a decision of evidence of the parties. The trial court held, please mark. Para 8. The trial court held that the appellant had failed to prove that he had paid a sum of rupees 25,000. This is going to be the crux of the case, because all courts agreed on this factual finding that the buyer had not paid the full amount. Buyer had not even paid the part amount. 25,000 was not paid. The trial court, however, held that the appellant had acquired title to the suit property, and this is what the High Court and Supreme Court are going to satisfy. The trial court, however, held that the appellant has acquired title to the suit properties when the sale deed was duly registered and was entitled to declaration of his title as in his possession with mean profits. According to trial court, remedy of respondent was only to sue the appellant for remedy for consideration mentioned in the deed, but they are stopped from denying his title. Para 10. Feeling aggrieved, first appeal. District judge also held the title of the appellant to the suit property was established. So, two courts concurrently gave one finding against me that 25,000 advance has been paid, but legal finding was given in favor of the buyer that title has passed on, regardless of that. Para 11. After holding that the appellant had failed to prove the payment of 25,000, the district judge held that the appellant was due in respect of the balance consideration of 40,000. District judge clarified that the appellant would be entitled to possession of the suit property only after he deposited the same. So that's a peculiar finding given. That no, title has come, but you won't get possession until unless you pay the remaining advance amount. Court, at least the medium of court will not come to your rescue to get a confirmation of your title. Para 13. The respondent invoked jurisdiction of the High Court by way of Second Appeal, Section 100. High Court was of the view that the intention of the parties was, and here the relevant portion starts. The intention of the parties was that the title would not pass to the appellant till the full consideration was paid to him, paid by him to the respondents, and that title to the suit property never passed to the appellant as he was not paid full consideration. Para 14. Sorry, para 15. Para 15. So, in addition, this is the factual scenario in that case. The para 15, the Supreme Court starts giving its own finding. The question posed for our consideration is whether title to the disputed property is passed to the appellant when the sale deed was registered, though admittedly no amount was paid towards consideration to the respondents. Sale is defined as being transfer of ownership or price. In the sale, there is absolute transfer of all rights in the property sold, no rights in actual transfer. The price is fixed by the contract, antecedent to the conveyance. Price is the essence of the contract to sale. There is only one mode of transfer by sale in regard to new property of the value of 100 or more, and that is value of estate. So this is a legal position. Now, here is the key paragraphs come, para 17. It is now well settled that payment of entire price is not a condition precedent for completion of sale by passing of title. They are giving legal position. If the parties have intended irredeemable, then matter would become different. That's what the Supreme Court is going to say. So it is well settled that payment of entire price is not condition precedent for completion of sale by passing of title, as Section 54 of Transfer of Property Act defines sale as transfer of ownership in exchange for a price paid, promised to partner or partners. This is all that is what the law says according to them, the statute says. If the intention of parties, and this is where the test comes, if the intention of parties was that title should pass on execution and registration, title would pass to the purchaser even if the sale price or partner of is not paid. In the event of non-payment of price or balance price as the case may be, thereafter the remedy of the vendor is only to sue for the balance price. He cannot avoid the same. He is however entitled to a charge amount. We may ignore that. Para 18. Normally, ownership and title to the property will pass to the purchaser on registration of the sale deed from the date of the execution of the sale deed. But this is not an invariable rule. As the true test of passing of property is the intention of parties. Intention is not this. So they say law has left scope for both. 54 has left scope for parties to agree on this or that, what they intend. When is the title intended to pass? At the time of registration, at the time of payment, before payment, after payment. So they say, I'm sorry, I just read that sentence again, but this is not an invariable rule. As the true test of passing of property is the intention of parties. Though registration is prima facie proof of an intention to transfer the property, it is not proof of operative transfer. If payment of consideration is a condition precedent for passing. So in addition, we have to test in this case whether the parties intended passing of consideration, payment, I'm sorry, the word is payment of consideration. I will not add my own words to judgment. Payment of consideration is a condition precedent for passing of the property. 19. Answer to the question whether the parties intended that transfer of the ownership should be merely by execution and registration of the deed, or whether they intended that transfer of the property to take place only after receipt of the entire consideration would depend on the intention of the parties. So that's repetition of what I was trying to emphasize. This is legal position, this is summary of legal position. Such intention is primarily to be gathered and determined from the recitals of the same deed. And I will come to my recital and show what I am trying to convey. When the recitals are insufficient or ambiguous, please mark this also. When the recitals are insufficient or ambiguous, the surrounding circumstances and conduct of the parties can be looked into for ascertaining the intention. Not when the recitals are clear. Subject to the limitations placed by section 92 of the evidence. So that conduct etc. evidence will come into picture only subject to limitation posed by 92, which says only and only the deed should be seen. So they say that it is possible to see the conduct. I'll just read one more paragraph. Paragraph 21. Applying the above mentioned principles to the facts of this case, we find, because irritative, after all, what happened in that case is also relevant. I should not skip that. Applying the aforementioned principles to the facts of the case, we find that the parties intended that ownership of the property would be transferred to the applicant only after receipt of the entire consideration by the vendors as a condition precedent. The operative portion of the sale deed clearly states that vendors have agreed to receive 40,000 rupees of the extra on the date of registration sale deed, that in consideration of payment to be so made, the property was being conveyed to the purchaser. This makes it clear that title was intended to pass only on payment of balance consideration of 40,000 in presence of sub-registrar. This is also supported by so and so. Title in fact did not pass either on execution or registration of the sale deed. Then para 22 is yet another circumstance. That what was that yet another circumstance? By which they have construed that the parties intended that property should not pass on here. The circumstance was the possession was also not given. The deed was also not given. So they say if really the intention of parties was that the title, last sentence of paragraph 22. If really the intention of the parties was that title of the property should pass to the applicant or the deed, as they say, the position of the suit properties would have been delivered. In my case, we will come to that later. I say position was delivered. Please see my
According
deed.
to you, what is the intention
Yes,
of the
my deed. Please see my deed.
The first you say that what is the proposition, then we will see the deed.
My proposition is that the recitals in the deed show that the property is intended to pass at the time of registration of the deed, and the payment would come to him later. It is very important to see the deed.
And the agreement is of a deferred payment. That's right. This is what you want
I
to
don't
say.
want to use that language.
You have to put in amongst the three terms which are there in
Yes, yes, I'll do that. We see the deed.
we will see that. Under which term you want?
The parties agreed that the payment will be made by check today, which means the parties have agreed that the payment will actually come to him later.
That's right. So
That's what the
also
check is.
under these three terms, price paid, promised or part paid, price paid or promised or part paid and part promised. Amongst all the three
Not
terminology
promised.
or promised.
Please take the deed. May I request?
In the case of issuance of check,
Read with the recital that the title
See
will
that.
pass on today.
you will see that. In a case of payment of consideration by check, why can't it be said that the parties intended that the property should pass on encashment?
There is no reason to say no. One has to say that. You know what is said. What is said is this, subject to acceptance only. Exhibit 1. Interview page 9.
You read it fully. page number 1.
Page number 1.
Yes.
Could I place what I was trying to
No,
place
no,
and
no.
then read the entire thing? Because I'll be able to make out a point.
That's right. You just read it.
I read from page 4. Page 4. The invitation will find the paginations immediately above the text. Just above the text, below the stamp. Has the invitation been able to decipher the page numbers?
Read from page 3.
Page 3.
Nature of
Nature of deeds saving, consideration amount 62,70,000. Whereas sellers are the absolute and lawful owners.
So दूसरा pen. Page 4.
Whereas sellers are the absolute and lawful owners of the land, more fully described in the schedule below, along with other land, and whereas the land measuring an area, so and so group situated in Moja, so and so, situated in so and so, recorded under Khata number, plot number, Jamshedpur, had been purchased by D. Satyanarayan Mohan Raju, son of so and so, by means of a registered sale deed, bearing deed number, date, area, in the same Moja Khata plot by means of a registered sale deed bearing deed number 6080 dated 11/12/1963, and similarly an area of land so and so in same Moja Khata so and so dated so and so, all purchased from its previous lawful owner so and so at Jamshedpur, and whereas since purchase of the above aforesaid landed property, D. Satyanarayan Mohan Raju had been in peaceful possession of the same without any interruption from any corner till death. And whereas in the Khatiyan of the last service settlement operation, the aforesaid Khata and plot has been converted in new Khata, and later on said so and so acquired the aforesaid landed property on the strength of title suit case number so order dated 5/7/76, and his possession with respect to the said property was confirmed by a judgment by the Court of Learned First Edition subject at Jamshedpur, and whereas after acquiring the said property, D. Satyanarayan Mohan Raju applied for mutation of the aforesaid property by mutation case number, and the ownership of said Raju was confirmed in respect of aforesaid land by rent fixation case. And since after rent is being paid for the said land to the landlord, the state through the CEO Jamshedpur in the name of D. Satyanarayan, and whereas after the death of said Raju, the aforesaid property vested and devolved upon his 4 sons as the surviving legal heirs and successors who acquired, and whereas Lakshman is traceless for last 16 years, not traced out till now, he was unmarried. And whereas thereafter, Satyanand, Shivan, Ram, and Krishna Mohan became the absolute and lawful owners of aforesaid property, and became partitioned the entire property left behind by their deceased father, Satyanarayan Mohan Raju, between them by means and bounds demarcating their shares of each, by virtue of which partition is scheduled below property fell to the exclusive share of the sellers, and since then the sellers have been in peaceful physical possession and occupation of the said property, more fully described in the schedule below, along with other landed property without any late entries of established family column. And as such, the sellers are the absolute and lawful owners of the same by exercising all acts of ownership thereto with power to dispose of the same in any manner they like. And whereas now being in urgent need of money, the sellers have agreed with the purchaser for absolute sale of the land measuring 26 decimals, fully mentioned in the schedule below for a total consideration amount of so and so. And the purchasers have agreed to purchase the same at the said price. Now this deed of sale witnesses that in consideration of said sum of 62,70,000 only, paid by the purchaser to the seller as per mode of payment, is marked these two expressions. In consideration of said sum, paid as per mode of payment herein below. The receipt of which sum the seller hereby admitted and acknowledged as full, final, and highest consideration of the schedule below land. And sellers by these presents do hereby absolutely sell, convey, transfer, and all that land mentioned in the schedule below in favor of the purchaser by this deed of sale to have and to hold the same unto the purchaser, his heirs, successors, together with all right, title, interest, and possession without any interruption from the side of the sellers. That the sellers have delivered possession of the schedule below land to the purchaser, and from this day is marked. From this day, the purchaser will possess and enjoy the same as an absolute owner of all possible gain, with power to dispose of the same in a manner he likes. That para 3 is very important. From this day, because the opening line of the deed is from this the 7th day of such and such. From this day, all that right, title, interest and possession of the sellers in the scheduled below land will cease to exist and will vest unto the purchaser, and the purchaser will become the sole and absolute owner from this. Sellers hereby declare that the land hereby conveyed by his with the deed of sale is free from all encumbrances also. Hereby declare that a good and perfect title, if for a defect of title, schedule is important. What is relevant for us is mode of payment, which is in the next page 13. Because this entire portion of page 13 has to be read into the opening line of the heaven. Mode of payment, check number, date 7, check number, date 7 February, 7 February, 7 February. All checks are of the same date. That is the date of registration. The date coincides with the date of execution and date of registration. Date coincides with the date which the parties have set is the date on which he will be divested and title will vest unto me. So what is clear from reading of this whole deed is that on 7th of February, parties intended that he will be divested of title. I will be vested with title. And the parties intended that the mode of payment will be checked, which means parties intended that the payment will actually come to him later. The language used in section 54 at 4 places is paid, partly promised. A person taking check and person giving check intend that the payment would actually come to him later. Check has been defined in section 6 of the negotiable instrument, derivation of penalty negotiable instrument. Couple of sections additional in my derivation standard NG2 to show the nature of transaction which check giver and taker. Show the nature of transaction which the check giver and taker would intend to enter into.
Liability to pay through check crystallizes on the date of issuance of check or it crystallizes on the date of encashment.
Liability to pay on the date of issuance. Therefore, he will have a good case for money suit. And that's what the Supreme Court said that if it is promised to be paid later, then you have a case for recovery of that money from the title holder. Now, a couple of sections here mentioned. Just to show that it is always the future. We all know from our common sense approach and general knowledge that check is a bill of exchange drawn on a specified banker, section 6, and not expressed to be payable otherwise they are on demand. So there has to be a demand following the check. And bill of exchange has been defined as in section 5 as an instrument in writing containing an unconditional order signed by the maker directing a certain person, that is a third party, a bank, to pay a certain sum of money only to or to the order of a certain person or to the bearer of the instrument. Now this definition is followed by section 30 and 31. That says liability of drawer, which was your ladyship's question. The drawers 30. So there has to be an order in future. 30. Liability of drawer. The drawer of a bill of exchange or check is bound in case of dishonor by the drawee or acceptor thereof to compensate the holder, provided due notice of dishonor has been given or received. The drawer is given. So the liability would continue. And that is why criminal law also gives me an opportunity. Check is dishonored, called upon to pay. And 31. Liability of the drawee of the check. The drawee of the check, that's relevant language. Drawee of the check having sufficient funds of the drawer in his hands, that is the bank, properly applicable to the payment of such check, must pay the check when duly required so to do. So he has to require it in future. He takes a check on 7th, dated 7th, and he will require it as per this. That's what law contemplates. I'm just inviting. I leave it upon your edition to see what the relevance of this is, but I found it relevant. Must pay the check when duly required to do so, and in default of such payment was compensated. Then, your edition is the last section which I wish to show. 64. What 64 contemplates about his responsibility, an action to be taken by him. Your edition had seen.
It is not a case of dishonor object. Nor it is a case.
We are not on dishonor. Just please see 64. Please see 64.
I've seen.
Promissory note bill of issue your check must be presented for payment to the maker, acceptor or drawing. So he has to do something. He has to present it before the drawing thereof, respectively by or on behalf of the holder. In default of such presentment, the other parties are not liable. So it is open. Law contemplates that he may be a defaulter in presentment, or he may not be. Therefore, intention of the parties which has to be gathered from the language is the mode of payment as contemplated in the deed. Mode of payment as contemplated is the deed is check dated 7th of February. The date is important. Coupled with the recital, coupled with the stipulation in the deed, that title vesting and divesting happens today. So therefore, my respectful submission is that the parties intended, parties with eyes wide open, one of the understanding that the payment would come to him later. What happens later is a separate part of the story. What happens later is to be three possibilities. When a check is passed on, there are three possibilities. There is situation by which payment would come to him. First situation is with the aid of the legal process relating to banking. That means you present the check, get it encashed, money comes to you. Second is the process, legal process involving court. That means you issue a notice under 138, and then give another notice. You present the check, have it disordered, give a notice, he pays, matter ends. If he doesn't pay, go to the court, you get the payment. And third is when neither dishonor takes place because of my default, nor honor takes place because of his default. He doesn't present it for whatever understanding we have reached. But instead of check, I give him payment by some other transaction, which is the case we have sought to develop, believable or not believable. So in either of three cases, his remedy was to get the money from him. Law comes to his aid. If the bank doesn't encash, he can file a writ against bank. If the check gets dishonored, he can file a criminal case against me. If we have reached another understanding by which check was not to be presented by him, not to be honored or dishonored, but he has to receive payment from me by some other mode because of something which he has done under a contract or as a non-gratuitous act, then his remedy is a civil suit. So either way, criminal case or civil suit in three different circumstances are contemplated by law. Law gives him a remedy. But so far as this is concerned, passing of title has taken place because the parties intended to pass on the date when the registration, execution all culminated in one. And that's submission of mine. And in addition, Keval Krishna judgment which my learned friends have. Keval Krishna, which was 2022 volume 18 SCC 489. Should I pass on? So 2009 is distinguishable, which we just discussed from my case. And likewise, this judgment would be distinguishable. Paragraph 18 is the relevant portion which here will add upon. Paragraph 18, section 54 of the Transfer of Property Act reads thus: hence, a sale of an immovable property has to be for a price. The price may be payable in future. It may be partly paid and remaining part can be payable in future. The payment of price is an essential part of the sale covered by section 54. If a sale deed in respect to immovable property is executed without payment of price and both conditions must coexist, and if it does not provide for the payment of price in a future date, it is not a sale. My deed does not fall in that category. My deed says that I am giving you a check. So payment will be paid in future. That's the implied understanding. So in the backdrop of this legal position, our cases are distinguished from the cases in which the court has held otherwise. Therefore, paragraph 19 of this judgment, evaluation, was concerned with the fact of that particular case. There they said that the sale deed will have to be held to be void. Because in both the sale deeds it was recorded that consideration has been paid and it had not been paid. In my case, the correct meaning would be that there is an understanding the condition precedent is not passing of money to him. Condition precedent is passing of a check to him, a promise to him, a guarantee to him. And that is what Section 54 contemplates. In fact, Section 54 is ideally suited, those three circumstances are ideally suited for a case like check transaction. Since we have something in place like a check transaction, therefore 54 has been engrafted in section 34.
The learned counsel for the respondent has submitted that his arguments would be touching upon factual aspects and also legal aspect with respect to section 54 of Transfer of Property Act, read with the provisions of read with section 6, 30, 31 and 64 of Negotiable Instruments Act and section 34 of the Specific Relief Act. With respect to the facts, we are submitting that as per the case of the plaintiff, first sale deed was executed on 7/2/2016 and the second one was executed on 17/5/2014. If the turn of events as narrated in the plaint is taken into consideration, the natural course of conduct is taken, then there was no occasion to execute the second sale deed, that is 17/5/2014. He submits that on 7/2/2014, the sale deed was executed upon issuance of 4 check, and on 22/2/2014, which was followed by 3 letters dated 22/2/2014, 28/3/2014 and 8/3/2014. In connection with the first sale deed, the learned counsel submits that in letter dated 22/2/2014, a letter was said to be served upon the plaintiff that when the defendant went for mutation, he came to know that the property cannot be mutated as the property is a government land. And the defendant requested the plaintiff to return the check and initiate the process of cancellation. The letter dated 28/3/2014 is a reminder to that effect. And the letter dated 8/4/2014 is the letter said to have been issued by the plaintiff, by which the plaintiff claims that all the checks were returned. These documents were marked. The sale deed was marked Exhibit 1, and these documents were marked Exhibit 2, 2/1, and 2/2. The learned counsel submits that if the defendant was aware that the mutation would not take place during the period from 22/2/2014 till 8/4/2014, there was no occasion for the defendant to enter into another sale deed with respect to adjoining area.
This slide correction is the defendant was of the view that sale has traded has to be cancelled and check has to be returned because mutation will not take place. Then, so mutation will not take place. I may have been aware, but I may not like to cancel the transaction. I am against that.
And that the sale
Check will be returned.
the defendant was, since the defendant was conscious of the fact that the sale deed was to be cancelled and the check was to be returned with respect to the first sale deed, there was no occasion for the defendant to enter into the second sale deed on 17/5/2014.
I leave it upon you.
The learned counsel has submitted that the description of property in Schedule 2 and Schedule 3 is identical except with respect to the area. He submits that the property in Schedule 2 and 3 appears to be adjoining to each other.
Same khata and same plot. Plot number is same.
The learned counsel then submits that this itself indicates that the Exhibit 2, 2/1 and 2/2 were forged and fabricated documents. The learned counsel then referred to the second sale deed dated 17/5/2014 and he submits that identical letters with respect to the second sale deed have also been said to have been issued. That is dated 1/6/2014, 15/6/2014 and 1/7/2014, which have been marked Exhibit 2/3, 2/4 and 2/5 respectively. Both the letters have the same tenure and it appears that they all have been prepared at one point. The learned counsel has then submitted that such a conduct is absolutely unnatural and therefore this aspect of the matter is to be kept in mind while considering the genuineness of Exhibit 2, 2/1, 2/2, Exhibit 2 to 2/1.
Overall genuineness of the factual case set up by him.
He says that the factual case which has been set up by the plaintiff does not appear to be genuine and probable. The learned counsel then referred to the exhibit.
In addition, the genuineness I have question also of 2/3, 2/4 and 2/5.
Yes. Then the learned counsel then referred to
Exhibit E, the plaint of the previous.
the plaint filed in the previous suit and in which was exhibit?
Exhibit E.
Exhibit E.
And I have highlighted the difference between paragraph 9 and 10 of each.
and has highlighted the difference between paragraph 9 and 10 of the present plaint and corresponding paragraph 9 and 10 of the previous plaint, and has submitted that in the present suit much improvement has been made and there is a difference in the case of the plaintiff.
Because I am leaving it upon your ladyship to yourself see and then appreciate.
The learned counsel has then referred to exhibit 3.
Yes. Vis-a-vis paragraph 18, 19 and 22 of the plaint.
Which is said to be an agreement of sale with third party, which is dated 12/8/2016, and I submitted that this has to be seen with reference to paragraph
18, 19 and 22.
18, 19 and 22 of the plaint. He submits that the legal notice was issued by the plaintiff on 23/8/2016, which was subsequent to exhibit 3, and its reply was given on 9/9/2016.
Which is also something. And in paragraph 22 he says thereafter.
But in paragraph 22, the term till thereafter has been
Thereafter
mentioned.
executed another agreement. In the leadership language of 22, it says that what is referring to is this exhibit 3D. It says thereafter executed another agreement in favor of another person for transfer of land mentioned in schedule 4.
The learned counsel submits that the plaintiff has made out a case that agreement of sale with third party was made after the issuance of legal notice, considering the sequence of facts as mentioned in the plaint.
What's important in this paragraph says and delivered possession to him. Because why fight on possession?
That's
The
it.
judge will have to decide.
And
He
he
saying
has,
possession is
and has
with him.
also stated in paragraph 22 that possession was delivered to third party.
The language is at the same time delivered possession.
That's it.
That means after these notices, he has delivered possession.
He submits that the plaint, the exhibit 3 the plaint reveals that after the notices, the property was delivered to third party right at the on the date of execution of agreement with third party. The learned counsel then referred to Order 825 of CPC and has submitted that merely because the 6 letters in Exhibit 2 series have not been specifically denied in the written statement, but still the court, considering the aforesaid circumstances, would certainly see as to whether the plaintiff has duly proved the aforesaid exhibits in the light of the flow of events and the circumstances.
Yes, actually, do you prove the facts which he wants to prove with the help of these
That's true.
documents?
And as to whether the plaintiff has been able to prove the facts as narrated in the plaint. The learned counsel then referred to section 54 of the Transfer of Property Act and has submitted that it is to be seen as to whether passing of money is a condition precedent in the present case.
Was intended to be a condition?
Was intended to be a condition precedent. He submits that for that purpose, the recital of the sale deed is relevant, and the fact that checks are issued itself reveals that the money would come to the seller only upon presentation of check. And apparently the execution of registered sale deed coupled with payment through check would fall under promise to pay at a future date and cannot be termed as payment on the date of execution of this. The learned counsel submits that under such circumstances, if the payment is not made by encashment of check for any reason whatsoever, the seller has a remedy to sue for the consideration amount. But the fact that the sale deed was registered and the title was passed on the date of registration cannot be disputed.
No, and the deed says that the title passes today.
The learned counsel has also submitted that the registered deed itself uses the word that the title and possession
Yes, possession and vesting of title.
passes on the date of registration, and therefore encashment of check at a later point of time will not make the sale deed null and void for want of consideration on the date of registration of the sale deed. Yeah.
जी language का registration का ये execution था. That recital and see.
The learned counsel has in particular referred to paragraph 3 of the sale deed.
Yes. This date, the date of execution and registration both are same.
Paragraph 3.
Yes. So execution and registration कर दिया है. जहाँ मेरा
The learned counsel submits that execution and registration was intended to be on the same day, and the title passed on the same day. The payments to deferred as the check was to be encashed. The learned counsel then referred to section 6, 30, 31 and 64 of the Negotiable Instruments Act, and he submits that recovery through check is either through presentation, and in case the check is bounced, it can be through the legal process of proceeding under section 158 of Negotiable Instruments Act. And in case the check is not presented or not honoured for any other reason, and if recourse to section 138 is also not taken, then the party has a legal remedy of filing a suit for recovery of money. The learned counsel submits that, therefore, an objection has been taken in the written statement that instead of filing a money suit, the plaintiff has chosen to file a suit for declaration of the sale deed as null. The learned counsel has then referred to the judgment passed by the Honorable Supreme Court reported in bracket 2009, bracket close code SCC 193, and has placed the entire facts of the case and has submitted that in the same case, the party intended to pass the entire consideration amount on the date of registration, but only part payment was made, and therefore the Honorable Supreme Court was of the view that the registration of the sale deed did not pass the title of the property. The learned counsel has submitted that the principle of law involved in connection with passing of property has to be based on the facts and circumstances and the intention of the party on the date of registration,
where the condition is
as to whether the condition precedent, as to whether the parties intended to transfer the property only after receipt of the entire consideration by the vendor as a condition precedent is required to be examined. He has referred to paragraph 15 onwards. Today almost.
Yeah, law has been laid on 17, 18 and 21.
15 to 21 and also paragraph 20 of the judgment. The learned counsel submits that the judgment which has been relied upon by the appellant reported in bracket 2022 bracket close 18 SCC 489 does not help the appellant in any manner in as much as in the present case, it is not a case that the sale deed was without payment of price or it did not provide for payment of price at the future date. Rather, the sale deed was coupled with issuance of check which was to be encashed at the future date.
I have seen previous judgment, I have also relied on the point that the intention of the parties have to be seen from the recital in the statement.
The learned counsel submits that the intention of the party would also reflect from the recital of the statement.
Yes. Only if the recitals are not clear, we have to go to conduct etc.
And if the recitals are not clear, then the conduct of the party is required. What else?
The next submission is that our case is that we have paid. That litigation was seen. I don't want to repeat the whole thing. I leave it upon the best judgment of the litigation to decide on this. Whether my story of payment having been made to him or his nominees through myself or my children, whatever,
The
is
story of the
believable or
payment
not.
is not reflected in your written statement.
In the written story is not very well drafted. Evidences have come. I leave it upon your litigation. Then the most important aspect of the litigation, impact of section 22.
The learned counsel has submitted that the payment has been made through alternative mode.
To the plaintiff or his nominees.
To the plaintiff or his nominees,
Much more than this. Yeah.
which is much more than the amount involved in the deeds,
Checks, yes.
in the checks involved in this case.
In addition, the next important argument is regarding section 22. My contention is that if they were specific, 34 of specific fact. Actually, in the old act it was 32. So, examining the judgments, I found that there are two judgments which I rely upon. Straight away edition, 1973 to SCC page 60. It's a short pronouncement, but by the largest bench. Therefore, I have got it. It's by a 3-judge bench. Subsequent all judgments are 2 judges. I rely upon 2 judgments. One is this. It's a very short judgment here. It's paragraph 4 paragraphs only. Plaintiffs appeal by specially Brown side and Raghuvi side. The plaintiffs are brothers. They jointly own suit property with Shabili Kaur. After the death of Shabili Kaur, Ganga Devi, the defendant in the suit, came forward as the legal representative of Shabili Kaur and got the mutation effected in her name in the place of deceased Shabili Kaur. In 58, the plaintiffs brought this suit for a declaration that they are the sole owners of the suit properties. In addition, similarly, my learned friend brings a suit which impliedly is for a declaration. That's his case, that it's a declaration that he has prayed for when he has asked for return of the deeds. He asked for declaration of my deed as void, and thereby a declaration that the title is not with me but with him. They did not claim possession. I'll read it further. They did not claim possession either the entire or even a portion of the suit properties. The fact finding courts, mainly the trial court as well as the appellate court, have come to the conclusion that during the lifetime of Shabili, she was in possession of a portion of the suit properties and the other portion remained in possession of the plaintiffs. Further finding reached by those courts is that after that, that's not relevant. The courts will have come to the conclusion that the present suit falls within the scope of section 209 of the UP Act, and the suit not having been brought within the period of 3 years, the suit is barred by limitation. The High Court agreed with the conclusion. We are not concerned with that. In addition, please mark this. There are 3 last sentences. In addition, it held that the suit is in by section 42 of the specific relief act. In addition, those days, this case was under the previous specific relief act, where section 42 was the corresponding section. We are in agreement with the High Court that the suit is held by section 42 of the specific relief act. as found by the fact-finding courts, Ganga Devi is in possession of some of the suit premises properties. That leadership is a question which leadership will consider now, because the trial court has held in my favor on the point of possession. The plaintiffs have not sought possession of those properties. They merely claimed a declaration that they are the owners of the suit properties, as the suit is not maintainable. In this circumstance, it will not necessarily go into the other contention. The suit is not by limitation. Likewise, the leadership may not go into the contention of section 54 and all if it is found that suit is hit by section 34.
The learned counsel
Now,
has referred to section, now the learned counsel has referred to section 34 of the Specific Relief Act and has submitted that the suit was barred by the same section. He submits that the corresponding section under the Specific Relief Act 1877 was section 42. He has referred to the judgment passed by Honorable Supreme Court reported in bracket 1973 bracket 2 SCC 660 and has referred to the facts of the same case wherein the plaintiffs had brought a suit with respect to property which was partly in possession of the plaintiff and partly in possession of the defendant, but did not seek any claim for recovery of possession, and consequently the Honorable Supreme Court held that the suit was barred by section 42 of the Specific Relief Act of 1877. The counsel submits that in the present case, the trial court has recorded a finding that the defendant was in possession of the property. He submits that the plaintiff has not sought any relief for recovery of possession, and therefore the suit was barred under section 34 of the Specific Relief Act.
The other ruling which I am respectfully relying upon is Venkat Raja versus Vidyane, reported in 2014, volume 14 SCC, page 502. The relevant paragraphs would be paragraph 23 and 24. May I read it?
Yes.
The very purpose of the proviso to section 34 of the 1963 Act is to avoid the multiplicity of the proceedings and also the loss of revenue of court fees. When the Specific Relief Act 1877 was in force, the 9th report of the Law Commission of India 1958 had suggested certain amendments in the proviso, according to which the plaintiff could seek declaratory relief without seeking any consequential relief if he sought permission of the court to make his subsequent claim in another suit of proceedings. However, such an amendment was not accepted. There is no provision analogous to such suggestion in the 1963 Act. A mere declaratory decree remains non-executable in most cases generally. However, there is no prohibition upon a party from seeking an amendment in the plaint to include the unsought relief, provided that it is saved by limitation. However, it is obligatory on the part of the defendants to raise the issue at the earliest. Then there are citations which have been relied upon. So, in addition, the submission is, in sum and substance, that this was a relief which they should have sought for at least after they were faced with my written statement denying their possession. They took a risk they were entitled to. They took a risk of not preferring any amendment and to go ahead with their case that they are in possession. And that brings me to the last submission of mine as to who is in possession.
Yes. The learned counsel has then referred to the judgment passed by the Honorable Supreme Court reported in bracket 2014, bracket 14 SCC 5202, and has referred to paragraph 23 and 24, and has submitted that once the written statement was filed stating that the defendant was in possession of the suit property, the plaintiff ought to have amended the plaint seeking recovery of possession, but no such steps were taken by the plaintiff, and ultimately the possession having been found in favor of the defendant, the suit was hit by section 34 of the specific.
This brings me to the last submission of mine. As to who is in possession. Leadership in the plaint, they said that the possession was with them and then passed on to the third party. So far as parting of possession in favor of a third party, the leadership has already noted my submissions by reference to paragraph 18, 19, 22 and exhibit 3 that the story should be not, the story should be discarded. Very specific contention in para 22 is plaintiff thereafter executed another agreement in favor of another person for transfer of lands mentioned in Schedule 4 and at the same time delivered possession of Schedule 4 lands to him who is raising construction of the building therein. I have denied and claimed my possession in my written statement and in the last sentence of my evidence in chief also that I am in possession. Faced with this, and this gentleman, Arun Kumar Thakur, with whom he says there is an agreement, has also deposed in his favor. So their story joined together, the plaintiff and his so-called agreement holder, their story is case discarded by virtue of the discrepancy they are shown in the plaintiff vis-a-vis the document. And that is the reason, to my mind, why they did not specify the date, because they wanted to give an order in a different manner of the events that have taken place. But the evidence ultimately shows, the document speaks.
Have you given a date of your position?
My position is, I rely on the deed, not pleaded in a date of position. My written statement is, that's very pertinent. So my submission is, while there was evidence before the court by way of oral evidence versus oral evidence, oath versus oath, one believable and another slightly unbelievable because of that discrepancy of that third party. The court has to see the documentary evidence. And by virtue of section 91, 92, in any case, it is the documentary evidence only which should be seen. Assuming that oral evidence could be seen, oral evidence is from both sides. And best evidence would be, in the event one was saying, I was saying that I have developed, they are saying they have developed, then either party would have paid before the court for appointing a commissioner, local inspection. None of the parties resorted to this. Now there comes the provision of the Evidence Act. Provision of the Evidence Act, section 101 to 104. May I just place the sections for a moment? Burden of proof. Whoever desires any court to give judgment as to any legal right or liability, dependent on the existence of facts, which he asserts must prove that those facts exist. It is his burden of proof, that's one. Read with the next section on whom the burden of proof lies. The burden of proof is in a suit or proceeding lies on that person who will fail if no evidence at all were given on adversary. So that shifts the entire thing on him. He has to discharge. He has not given the best evidence. He has already said something I have denied, I have already said something he has denied, but my denial of my oral statement takes a back seat. And there is a document. Read coupled with section 91 and 92, I have discharged my burden of proving. Paragraph section 103, burden of proof has to a particular fact. The burden of proof as to any particular fact lies on that person who wishes the court to believe in its existence, unless it is provided by any law that the proof of that fact shall lie on a particular person. Now, in order to bring home his case within a category of cases which is not hit by section 34. Only way is to say that I am in possession. Therefore, why should I pray for possession as a consequence? So it is he who would fail if no evidence is given by either side, and law requires him to do this. That's my respectful submission with the aid of section 101, 102, and 103.
The learned counsel for the respondent has referred to the point of possession. He submits that both the parties have laid oral evidence on the point of possession, which are contrary to each other. And in the pleadings also, they are claimed possession. He has submitted that the sale deed itself reveals that the sued property was, the possession of the sued property was given on the date of execution of the sale deed. And therefore, in the matter of conflict between oral evidence, in the matter of conflicting oral evidence, the document which is a registered sale deed was required to be seen, is required to be seen, and has the learned counsel then refers to section 91 and 92 of the
Usually the first argument is the oral evidence is excluded by operation of 92.
The learned counsel submits that the oral evidence is excluded on the face of the documentary evidence, that is a registered sale deed, which itself revealed that the possession was given on the date of registration.
That's first argument.
He has then submitted that the plaintiff claimed to be in possession of the property, and in order to come out of the rigors of section 34 of specific relief act, it was for the plaintiff to prove that the plaintiff was in possession of the property. He says that the burden of proof was on the plaintiff to prove that he was in possession of the property, which the plaintiff miserably proved. The learned counsel miserably failed. The learned counsel has referred to section 101 to 104 of the Indian Evidence Act, and he submits that the plaintiff, having failed to discharge his burden of proof with regard to possession, and on the face of the registered sale deed itself, the defendant has successfully demonstrated that the possession was delivered on the date of registration. Therefore, the suit was rightly held to be barred by section 34 of the specific.
Small assumption. The fact that possession is mine is also relevant because that will reflect upon what the parties intended with regard to passing of title. Supreme Court has said in that judgment that one of the consideration on which we should say that the parties intended to have the property transferred or not to have the property transferred was giving or not giving of possession. In that case, possession was not given. In this case, if they want to take use of possession having not been given, in order to show that under section 54, the case would fall in their favor by holding that they never intended the title to pass on. It's their burden to discharge that possession is given.
The learned counsel has also submitted that
Not only section 34 of the SPC but from this angle also.
the learned counsel for the respondent has also submitted that section 34 is to be seen from another angle. He
Not
submits that
section 34, Your section 54.
section 54 is to be applicability of section 54 of the Transfer Property Act is to be seen from another angle. He submits that in the judgments which has been referred to by him, it reveals that the factum of giving possession by itself is an important aspect to determine as to what the parties intended at the time of execution of the at the time of registration of the secret. The counsel submits that the fact that the possession was handed over to the defendant at the time of execution of the same deed itself speaks volumes that the parties intended that the property should pass on to the defendant on the date of execution of the same deed, and payment of consideration was at a future date upon collection of the amount covered by it.
That's a separate one. And therefore, the burden of proof lies on him by virtue of section 103 of the evidence.
And therefore, the burden of proof was upon the plaintiff by virtue of section 101 to
103. 103 in particular.
by virtue of section 103 of the Indian. That's all.
To prove that position is weak, they will not be.
To prove that the position was with the plaintiff and not with the defendant. अब आपको क्या बोलना है?
I got a fraud वगैरह का allegation that a clandestine and I've got online submission. Because fraud requires sufficient pleading.
जो चीज pleading में नहीं रहता ना आपको सुनाई
नहीं clandestine वगैरह लोग plead किए हैं. plead किए आर्ग्यू किए हैं इसलिए कि एक judgment है litigation उसको नोट कर लिया है. His argument with respect to fraud and clandestine clandestine manner in which the transaction took place, my answer is that there is lack of sufficient particulars, and I rely upon one judgment, Shanti Dudia, reported in 2010, volume 4 SCC, page 104. 2010, volume 5 SCC, page 104, paragraph 22, 32 and 33. 32 and 33.
The learned counsel has also submitted that the plaintiff has alleged that the defendant has acted in a clandestine manner. But such reading, but there is no particulars of such clandestine manner in the plaintiff.
The fraud word has been used, therefore I am saying.
Fraud word नहीं
Fraud
है.
word is नहीं.
Fraud word use नहीं है. दिखाइए कहाँ use है.
In para 21, we have used the word clandestine.
Yes, I have seen that. For this, he has referred to the judgment passed by the Honorable Supreme Court reported in bracket 2010, that was 5 SCC 104, paragraph 22, 32 and 33.
Para 21, fraud word has been used.
Paragraph 22.
I will just read it. Which he obtained after getting, plaintiffs entitled gets to original sale deeds which was obtained by defendant in a clandestine manner because plaintiffs have acquired a right to receive the original sale deeds from the defendant which he obtained after getting registration slip from plaintiffs who are practicing fraud. He is giving up the right to
नहीं, हम तो आर्ग्यू भी नहीं किए हैं फ्रॉड पर हम
ठीक यही नोट कर लिया जाए. Defendant is not required to answer this.
The clandestine and fraud. Yes.
Therefore, I had started from the first day. I said that I have multiple problems. One of them being Mr. Pandey Neeraj. The voluminous document there are two judgments on which he has relied is related to section 34. My submission would be absolutely simple because that is there in the statute itself. Section 34 itself says that you cannot simply pray for a declaratory relief. If you are entitled to a consequential relief, you do not pray then. So no judgment is required on that aspect. I cannot differ with that. If I am not in possession and if this is the final report that I am not in possession, then my suit would obviously fail. But I have right throughout, I have claimed that I am in possession.
This is a very important submission by my benefit that may be noted.
I will not whatever I want to. Please.
Oh, that's a submission.
I will please put ऐसे ना बात तरीके से नहीं
तो हमको
समझ.
लगा
हम मंडे करेंगे हम
I'm
just
sorry, I thought he has finished.
हम just
I'm very
start कर रहे हैं and then with regard to 2009 वाला one of our honorable, this is on the lighter, one of our honorable judges is retired now. If this would have been placed by him, then he would have said very fair of you, counsel. This was Justice Patel. इतना अच्छा से fairly he has placed the judgment 2009, I could not get it. I must say that I did not get this judgment, and my whole argument would be based on this. now.
Fair,
Apart from the two judgments which.
fair eligible.
So, on Monday, Your Lordship.
The learned counsel for the respondent has concluded his argument for rejoinder post on Monday. उस दिन full stop. उस दिन तो हो जाएगा ना खत्म.
हाँ. I'll not take much time.
थोड़ा आप अपना
नहीं, इसी
रूल्स
के
अगर
लिए-
आप बता देते
हाँ.
तो हम भी थोड़ा काम करके आते हैं होता तो कोर्ट में नहीं.
अच्छा वो तो हम बैकग्राउंड बता
थोड़ा सा
दें.
आपका
हम-
रिजॉइंडर का क्या कंटूर्स होगा खाली
हम नोट किए हैं, but I just didn't want to conclude it today.
That's right. You can just indicate
Yes,
what
yes.
all you are saying.
Your Lordship, the sale leads, Your Lordship would find that the suit property is a vacant land. And if it is a vacant land, there cannot be any possession or dispossession. And I'll be relying on that judgment which I have relied in another case before Your Lordship, that whoever with regard to whenever possession of a vacant land is to be considered as to who is in possession, then it has to be seen as to who has the right to possess. Because there cannot be any other proof in a vacant land. There can be proof when it is of agricultural land, someone is doing agriculture or someone has already constructed and is staying there. Then that would be a possession, proof of possession. But over a vacant piece of land, there cannot be any proof of possession. Whoever has a right, he would be deemed to be in
I
possession.
remember I've seen that.
Yes.
What else you have? What about the whole issue about passing of time?
Yes, passing of title. Now, very interesting. Your Lordship, entire title they say, this is not a case pleaded by the respondent, that it is an alternative plea to the transferee on the date, because this date of check is the same date of the date of sale. This is their contention. Now, on the other hand, in para 8 of their written statement, what they say, their whole defense is that it was only to be encashed after mutation was done. This is their whole plea, that it was to be encashed only after mutation was done, till the date when the defendant himself was being examined. He very clearly admitted no possession, no mutation has been done. So what would be the consequence? That my title and possession both he is entitled to retain, but I am not entitled to encash the check. Can this absurd plea be taken by the court? Would it not be an absurd plea that here he says that you can only encash it after mutation was done? This is whose whole plea is there. Check is dated 7/2/2014, and then he also says that no, mutation has not been done. Till the date he was being examined, and till today he cannot bring any evidence to show that means even as on date I am not entitled to that amount, although my title and possession both are lost.
Which is that para of the written statement?
Yes,
Para number?
yes. Para is para 10.
The learned counsel for the plaintiff in rejoinder has submitted that the suit property being a vacant land, the point of possession / dispossession has to be seen from a different angle of view. As vacant land cannot be, it has to be seen from a different angle. He has submitted that he shall cite a judgment to demonstrate that when the suit property is a vacant land, what has to be seen is who has the right to possess this. The Learned Council thereafter submits that the question of title being passed on the date of registration of the CAD does not arise in view of the specific stand taken by the defendants in paragraph 10 of the written statement that the check was to be encashed only after mutation. He submits that this itself revealed that the intention of the party was that the title would pass after mutation.
Yes, yes. After mutation only, and after obviously, therefore,
And
payment
after,
of consideration amount was
and
absolutely
consequently
essential.
after payment of consideration.
Consideration.
Okay, you continue on.
Yes, and he has admitted in para 23 of his cross examination that मुझे मेरे नाम से mutation नहीं हुआ.
And it is an admitted fact on record in paragraph 23 of cross examination of the defendant.
Yes, he did up to one.
DT.12.12.2025 that the mutation has not been done in favor of the defendant.
So I concede your leadership that when he sued for money, he should be getting that, despite the fact that mutation is not given. Very interesting things have come up. Whether title will decide the position or position will decide the title.
ठीक है, उसका भी हम जवाब देंगे.
I'm not joining issues. I'm saying legal nitty-gritties.
आप लोग दोनों रहेंगे तो something interesting has to come.
Anyway, he is title, I am position. I follow him.
हम research कर रहे हैं. हम काम कर रहे हैं.
नहीं, हम because your lordship asked me as to whether your lordship would, because your lordship.
Yes, I will do some
The
homework.
reason was your lordship may one more thing I'll point out.
Yes.
That this I also must admit that I also found it strange that why a second sale deed, one was executed in February, another was in May, and there were some similar, but all these fees are not before your lordship.
That's
There's no allegation of any of this nature before you. So this cannot be a ground.
That's correct. Whatever has happened with the consent of the parties, both sides, and what has happened is actually not reflected on the parties. We have our own limitations as counsels.
Yes.
I can guess.
But one thing is clear, that plaintiff's case is not truth. Defendant also may not be truth. What happens?
When the water becomes still, that is when the facts are clear, you can gaze at it.
From supplementary list for hearing, attempt 1st April 4 of 2015 along with attempt 3 to 5.
It will be a hearing. First it will be first case. Yes, what do you want to say?
In the second case, that is the 5 of 2014, we had to file a supplementary affidavit to get the communication. We have done that.
Paper, it has been published.
Yes.
The service is complete. Service is otherwise complete.
Yes. Against the two respondents, it was written that we get the communication.
The learned counsel for the applicant has submitted that the service of notice is complete through newspaper publication. The newspaper has been placed on record by filing a supplement. Accordingly, the service of notice is taken as complete. हो गया complete?
April 6 of 2014.
April 6. April 6 लिखा है.
Notices were issued to legal heirs of respondent number 1.
Item delivered. April number 6 of 2014. The learned counsel for the applicant has submitted that notices were issued to the legal heirs of respondent number 1. The item is shown delivered as per speed post tracking report. This means that the substitution will
No. I mean, FA number 7 of 2014. Other FAs are.
yes. What is that ID number?
100 of 2000.
IE number 100 in AP number 6 of 24. The name of legal heir has been mentioned in paragraph 9 of the eligibility application. Both have died, respondent number 1 and 2.
Yes.
Respondent number 1 and respondent number 2 had expired. It has been asserted that respondent number 2 was the son of respondent number 1, and the only surviving legal heir is Govind Marandi, son of respondent number 1 or respondent number 2?
Son of respondent number 1.
Son of respondent number 1 or respondent number 2? It has been asserted that respondent number 1 and respondent number 2 being mother and son, they have common surviving legal heir. तो इनके बाप का क्या नाम है? Adult son, whose son?
Bodha Manji.
From where you get?
Janmuni Devi, respondent number 1, is the mother of respondent number 2, Mahalal Manji, and Govind Marandi is the son of Mahalal Manji, respondent number 2.
The learned counsel submits that Govind Marandi is son of deceased respondent number 2. He may be substituted in case of respondent number 1 as well as respondent number 2. ठीक है? It has been also asserted that the application for substitution has been filed within 90 days from the date of knowledge of respondent number 1. And of respondent number 2. दोनों का within 90 days.
supplementary, we have also annexed the statement of Govind Marandi, the proposed substituted lawyer. He could not disclose the exact date, so we find it from the date of confirmation.
Considering the fact that notice has been served, but committee has entered appearance, the prayer for and being satisfied with the government's name in IA number 100 of 2022. The prayer for substitution of respondent number 1 and respondent number 2 is allowed. The learned counsel for the argument is directed to delete the name of respondent number 1 and respondent number 2 and insert the name of the Govind Marandi, son of Mahalal Manji, son of
Respondent number 2.
son of respondent number 2. In past acting indirectly during the proceeding. It is 4. First appeal 4.
4 and 7.
4 also the notice is served.
Yes.
इसका आगे बताइए.
Hence, 4 has been on the previous day, 4 of 14 was admitted
Yes.
after completion of service of notice.
Oh, it's complete. It's all done.
Yes.
और बाकी कौन है?
If it's 7 also was in order, so it has been admitted.
Appeal not eligible.
There was the order 26/9/2025.
26/9.
Order number 16.
Order number
16.
April number 7 of 2014 has already been admitted by the order dated 26/9. Passed in the case along with other analyses. Now, same order. We formally admit the others also.
Yes, it has been. It's been 5 and 6.
That April 5 of 2014 and April 6 of 2014 variated for 5. आपने सर
Respondent, first appeal 4.
किनकी तरफ से है?
Respondent number 2 की तरफ से. Respondent number 2 मर गए.
तो क्या substitution?
अब substitution फाइल हुआ था, allow भी हो गया.
allow
जी.
आपको instruction मिला है तो करना पड़ेगा.
तो फाइल कर दिए.
उनकी तरफ से फाइल हो चुका है?
जी फाइल कर दिए. उनके लड़के की तरफ से हम लोग ऑलरेडी है अपने लोग.
ठीक. तो इससे क्या है?
Chief, I am appearing for in first appeal number 7 of 2014 on behalf of the.
So, I just want to know, is it a covered case or it has to be argued?
No, it has to be argued.
Argued.
Yes.
So, what is the main point?
Land acquisition matter है and it is a case of no evidence at all. एक subsequent एक adjacent कोई गांव है उसका सेल डीड और उसके एक जजमेंट में जो फिक्स किए हैं उस पे कर दिया. कोर्ट हैज गिवन इट्स फाइंडिंग इन पैरा 5 as well कि there is no document to say what the claimant have received as the awarded amount, the amount.
Received means?
The claimants they received. Long
Entire?
back. Yes, long back.
Entire
15 years back. Thereafter they filed this reference case. No objection was ever raised. And after a lapse of 15 years, they again filed for enhancement of the compensation. The compensation was paid to the claimants. And without presenting any document on record, without getting exhibited any chit of document to say on what ground they are referring an enhancement, it has been enhanced because in some other village some amount was fixed.
So why did he refer the matter?
It should not have been, my lord. It is right from the inception this reference case is not sustainable. कोई डिस्कशन भी नहीं है कि आगे 15-17 साल ये केस हो रहा है और किस डॉक्यूमेंट के बेसिस पे किए वो भी नहीं, खाली फ्लैटली कि नहीं 600 रुपए कर देते हैं बिकॉज किसी और केस में हाई कोर्ट ऑफ झारखंड किसी और विलेज के लिए 600 रुपया फ्लैट रेट फॉर पर डेसिमल डिसाइड किया है. दैट इज द ओनली ऑब्जर्वेशन बाय द कोर्ट.
Did you read evidence?
Yes, we read.
Can you say it? Exhibited from your end?
Miller, this we say that it has rightly been. The onus is upon them, Miller, when they have come for the enhancement. 2013 का judgment is on that point. The party who approaches the court for enhancement, it is his onus to bring on documents on what ground, on what basis they are placing the case. They did not bring anything.
Which is that right?
2013, Miller. 2013, volume 14, SCC 50.
2013.
I'm giving a copy. Relevant para would be 10, 9 and 10. However, I was not prepared for the hearing this.
I just want to know the contours, how much time will it take? Para numbers
9 and 10 arrangements. May I read out? In land acquisition officer and Siddhartha Umana Kumari, a 3-judge bench was dealing with the case where the question that fell for determination was whether it was open to a reference court to determine the amount of compensation exceeding the amount of compensation determined in the award without recording a finding on consideration of the relevant material therein, that the amount of compensation determined in the award under section 11 was inadequate. Answering the question, this court considered the entire legislative scheme underlying the act and clarified that the claimant was in the position of a plaintiff on whom lay the burden of proving his case that the compensation awarded by the collector was inadequate. The following passage of, in this regard is apposite. Para 7 of that judgment. When the collector makes the reference of the court to the court, he is enjoined by Section 19 to state the grounds on which he had determined the amount of compensation if the objection raised as to the acceptance of the award of the collector under Section 11 by the claimant was as regard the amount of compensation awarded for the land thereunder. The collector has to state the grounds on which he had determined the amount of compensation where the objection raised by the claimant in his application for reference under Section 18 was as to inadequacy of compensation allowed by the award under Section 11 as required by subsection 2 of Section 18 itself. Therefore, the legislative scheme contained in Section 12, 18 and 19, while on the one hand entitles the claimant not to accept the award made under Section 11 as to the amount of compensation determined as payable for this acquired land and seek a reference to the court for determination to the amount of compensation payable for his land, on the other hand requires him to make a good before the court the objection raised by him as regard the inadequacy of the amount of compensation allowed for his land under the award made under Section 11 with a view to enable the court to determine the amount of compensation exceeding the amount of compensation allowed by the award under Section 11, be it by reference to the improbabilities by the award under Section 11, be it by reference to improbabilities inherent in the award itself or on the evidence adduced by him to that effect. That is why the position of the claimant in a reference before the court is considered to be that of a plaintiff in a suit requiring him to discharge the initial burden of proving that the amount of compensation determined in the award under section 11 was inadequate. So it was, onus was upon the plaintiff, the claimant themselves. How it was inadequate after sitting for long 15 and 17 years without raising an objection, all of a sudden this reference case was filed below, and then the amount has been enhanced.
तब करना है सर बताइए.
नहीं है. Next. The LCR has
रिकॉर्ड था क्या सर? कब करना है?
रिकॉर्ड्स तो मैंने पहले ही आ गया था, ऑर्डर में लिखा हुआ है कि
सब आप कब करना है आप?
Actually, my friend is making submission before this record.
Just to conclude what she wants to argue. अभी कुछ शुरू ही नहीं हुआ है.
नहीं तो ठीक है, तो इसको आफ्टर वेकेशन रख दिया जाए. आफ्टर वेकेशन जो है सब केसेस को साथ में रख दिया, जो 5 और 6 2 में भी कुछ मैटर है टैग्ड है, वो भी तब तक ही हो जाएगा. पहला सबमिशन माय लर्नेड फ्रेंड जो कर रहे हैं, ये कोई डॉक्यूमेंट नहीं है, कुछ नहीं है, और कंपनसेशन जो है उसको 600 रुपया कर दिए. हमारा कहना है कि ऑर्डर देखा जाएगा भाई लोग,
रिकॉर्ड ही लिखना पड़ेगा.
ये ऑर्डर देखना होगा. और रिकॉर्ड ऑर्डर में लिखा हुआ है हाई कोर्ट ने 600 रुपया कंपनसेशन अवार्ड किया है, उसी के आधार पर सिमिलर केस में,
सिमिलर मतलब उसी एरिया का.
इसी तरह इसी का केस, इसी केस में उसी गांव का, उसी गांव का.
Same village.
That is mentioned in the order.
अभी डिस्कस करने नहीं है.
Yes, yes, my lord. If that is true, it may be discussed.
Same village.
If that is the same village, my lord, I am out of the court immediately.
No, that is mentioned. I am reading the order.
पढ़िए कौन सा?
Order में लिखते हैं मतलब para 12 में. Kindly see was para 12 was the order passed by the king. Lordship, Lord it will. पास में उसको.
ये विलेज लाइलियो का है.
लाइयो विलेज. ये पिंड का है. हमारा पिंडरा है.
पिंजरा का. बगल में. एडजस्टेंट भी.
सेम विलेज नहीं है.
एक लाइयो का है लेडीशिप, एक परेश दारू समथिंग है. माय इज पिंडरा.
इसको हम लोग एग्जामिन कर लेते हैं रिकॉर्ड से, देख लेते हैं. ताकि रिस्पोंडेंट डेथ कर गए, उनके लड़के पार्टी बने हैं, उनके पास कोई डॉक्यूमेंट नहीं, उनके फादर देख रहे थे कि
डॉक्यूमेंट का केस कैसे जरूरत नहीं होता ना. आपको तो रजिस्ट्री ऑफिस से रजिस्टर्ड डीड निकालना है, और कौन सा डॉक्यूमेंट?
जब रजिस्ट्री ऑफिस से क्या कैसे केस लड़ रहे थे, क्या फाइल कर रहे थे, उनके लड़के जो पार्टी बने हैं उनको हम बोले भाई कुछ डॉक्यूमेंट है तो ला के दीजिए हमको, तो बोलते हैं कि हमारे पास पापा कहाँ रख दिए हैं, तो कुछ मिल ही नहीं रहा.
ठीक है, आप रिकॉर्ड देख लीजिए ना, रिकॉर्ड के बाहर तो
नहीं ठीक है. इसको जनवरी में कोई डेट कन्वीनियंटली रख दिया.
the consent of the learned counsel for the parties. This matter be posted for final disposal on. January in the
second week of January में कर दिया.
यहाँ बोले जनवरी में.
जनवरी में second week में 6 January,
6 January. 8 January रख देते.
या ठीक है.
ये 7 रख देते. ठीक है.
बाद में
जी.
बाद में ही रहने दिया जाए.
तो कौन सा तारीख?
First week of January के बाद. Any date convenient.
As your lordship, ladyship's convenience.
Your lordship convenient.
Convenience तो हमको आज भी
नहीं
कोई ठीक नहीं. 8 तारीख को रख देते.
या ठीक है.
इन सप्लीमेंट्री. सर रिकॉर्ड आपको मिल जाएगा, आपके कोई भी नियर यहाँ पर यही मिल जाएगा रिकॉर्ड.
I have taken the records note on my pen drive, which was immediately given to me. हाँ, तो हम अभी
हाँ शेयर करें.
तो
I will very soon. बस Orders in that direction.